Hi everyone, this is Tarikaji Chaudhary on behalf of Lamant representing the latest judgment of Supreme Court. Today here I am going to discuss about the latest judgment of Supreme Court on goods and service tax. Here it goes. Supreme Court upholds constitutional validity of goods and service tax. Compensation to States Act 2017. The Supreme Court on Wednesday upheld the constitutional validity of Goods and Service Tax Compensation to States Act 2017 as well as the Goods and Service Tax Compensation Change Rule 2017 as framed under the Act. The verdict was delivered by a bench of comprising Justice A.K. Sukri and Justice Ashok Bhushan. Here is a summary of issues dealt by the court and the court's response to the same. Issue number 1. Whether the Compensation to States Act 2017 is beyond the legislative competence of the Parliament. The petitioner has contended that although the impugned act was being claimed to be enacted for compensating states for loss of revenue, it in fact imposed this tax termed as cess, thereby falling outside the purview of the powers that it holds. The court, however, upheld the legislative competence of the Parliament to enact the law, pointing out that Article 270 after Constitution 100 and First Amendment Act 2016 especially empowers Parliament to levy any taxes by the law. Besides, it emphasized on the fact that Section 18 of the Constitution 101st Amendment Act 2016 expressly empowers the Parliament to provide for compensations to the states for loss of revenue arising on account of implementation of the Goods and Service Tax by law on the recommendation of the Goods and Service Tax Council. When Constitution provision empowers the Parliament to provide for compensation to the states for loss of revenue by law, the expression law used therein of wide import, which includes levy of any charges for above purpose. We thus do not find any merit in the submission of the learned counsel for the petitioner that Parliament has no legislative competence to enact the Compensation to State Act 2017. It concluded. Issue number 2 and 3. Whether the Act violates Constitution 101st Amendment Act 2016 and whether it amounts to colorable legislation. The court noted that the statements of objects and reasons of the Constitution 122nd Amendment Bill 2014 included the objective of conferring concurrent taxing power upon Parliament and the state legislature to make laws for levying goods and service tax. Article 246A subclause 1 is further noted empowers the Parliament to make law with respect to goods and service tax. Rejecting the first contentions, it therefore ruled the expression used in Article 246A is power to make law with respect to goods and service tax. The power to make law thus is not a general power related to a general entity, rather it specifically relates to goods and service tax. When express power is there to make law regarding goods and service tax, we fail to comprehend that how such power shall not include power to levy charges on goods and service tax. Besides, having held that the Parliament has full legislative competence to enact the Act and the Act having been enacted to implement the Constitution 101st Amendment Act, it is also rejected the contentions that the impugned act is a colorable legislation. Issue number 4. Whether levy of compensation to state and GST on the same taxing event is permissible in law. The petitioner had submitted that the Section 8 of the impugned legislation levies tax on intrastate supply of goods and services, whereas CGST Act has also been enacted to levy tax as provided under Article 246A of the Constitution. Chase they submitted is also imposed on intra-state supply of goods and services covered by Section 5 of IGST Act 2017. The petitioner had therefore contended that there cannot be two levies, one under GST Act and another under impugned legislation, as it would amount to double taxation on the same taxable event and the same subject. The court, however, asserted that two taxes imports which are separate and distinct and on two different aspects of transaction are permissible, as in law there is no overlapping. Goods and service tax imposed under the 2017 Act, as noticed above, the levy of cess on such intrastate supply of goods and service or both as provided under Section 9 of the CGST Act, and such supply of goods and service or both as a part of Section 5 of IGST Act is thus two separate imports in law and are not prohibited by any law so as to declare it invalid. It then explained. Issue number 5. Whether the payments made toward clean energy cess can be set off against payment of compensations to state cess. Lastly, the petitioner had submitted that having paid clean energy cess till 30 June last year on the stocks of coal, he is at least entitled to set off the same in the payment of compensation to state cess. The court, however, noted that the clean energy cess and the state's compensation cess are collected for wholly different purposes. While the clean energy cess was levied and collected for the purpose of financing and promoting clean energy initiatives, funding research in the area of clean energy, etc. State's compensation cess is collected to provide for compensation to the state for the loss of revenue arising on account of implementation of the goods and service tax. It then ruled that the petitioner is not entitled for any set of payments made toward clean cess in the payment of compensation to state cess, dismissing the petition. So, this much for today, and please don't forget to subscribe our channel Law Mantra for more legal updates. Thank you.